Hello everyone, it's Wayne Jones, the course coordinator for Australian Employment Law at Central Queensland University. This is week 1 of a 12-week course, and this presentation is part 1 of the presentation for the first week, and it will deal with an introduction to employment law. Our textbook is Stewart's Guide to Employment Law, and we're using the 5th edition. For this first topic, introduction and development and coverage, we'll be reading both chapters 1 and chapter 2, and for the moment I'll be talking about some of the highlights and some of the material you need to be aware of from chapter 1. If you do want to undertake any further or additional reading, you can do so. Have a look at the textbook Breen, Creighton and Stewart, Labour Law, particularly chapters 1, chapter 3 and chapter 6. I'll mention this textbook from time to time during the course. It is probably the textbook that most practitioners in the area will have on their shelf, but for our purposes I've gone for the more general and much shorter text, that is the Stewart's Guide to Employment Law. But I do make the point early that if you intend to practice in the area, you'll probably end up purchasing Creighton and Stewart's Labour Law. Let's talk about a bit of history. The relationship, particularly the relationship of master and servant. If you've done any torts law, you've probably heard the terminology already, that is master and servant. It's a very historical term, and it gives you probably quite correctly the vision that the employment relationship is a subservient one, where the servant does the bidding of the master. It comes from a time, of course, where there were no unions, and in fact more than that, even the concept of forming a union was illegal, so organised labour was illegal. And there were no minimum conditions for working. The balance for us these days, though, is more along these lines. It's between the economic rationalists, who would argue that the free market and deregulation are the order of the day, and that employees are best served in a healthy economy where there'll be plenty of opportunities for employment and plenty of opportunities to bargain for themselves. So it's not unusual to hear that deregulation of the labour market is argued for by a Conservative government, and on the side of perhaps the Labour side of politics, the motivation is much more along the lines of pushing for decent conditions, pushing for a safety net as basic human rights. You'll see in your textbook, in fact, a reference to the International Labour Organisation. Australia is a part of, is a member of the International Labour Organisation, and that organisation is all about promoting amongst its state members laws, regulations about child labour, about equality of pay, about respect for collective bargaining. But whatever your view, there's certainly no argument that at some level regulation is required for the labour market. The argument is simply whether or not it's there to protect the economy or to protect the workers. Let's think about now some of the sources of employment law and how employment law is regulated within Australia. Your textbook at page 3 takes us through some of the ways in which the Australian law employment law is regulated, and they refer specifically to agreements, written or otherwise, between the parties. They talk about industrial awards, both federal and state. Policies, not only policies within the workplace but government policy itself, rules and processes of the common law, and the international labour standards which I mentioned earlier. Just looking for a moment at the common law contracts, I'd ask you to remember that the whole employment relationship is often based on a contract, and that it is still a contract, so it has all of the different things that you'd expect from any other type of contract. You still require an offer, an acceptance, and there has to be an intention to create a legal relationship between the parties. So don't lose sight of the fact that the employment relationship is a contract, and these things still apply. Some of the different things about the employment contract, though, is unlike some other contracts, it can be verbal. It doesn't always need to be in writing, and it can be a combination of both. The terms and conditions of the contract will usually be around how long the contract is going to last, what sort of work is required to be done, and how long the contract is going to continue. There will be, in the absence of clear intention to the contrary, there'll be some conditions which will be implied. So, for example, if the contract didn't talk about how long it was going to last, the assumption would be, in other words, a fixed term contract, the assumption would be that the contract could be terminated on reasonable notice by either of the parties. There are also conditions which most courts are very happy to imply into a contract of employment, and a couple that are mentioned in your textbook are those around not disclosing confidential information and an obligation not to cause injury or damage to each other. There is also debate and quite a bit of case law on whether there is a mutual obligation of trust and confidence in employment contracts, and that's something that we'll talk about at a later stage. And just before we leave the question of contracts, just be aware of the terminology around whether something is a contract of service or a contract for services. There is not much that turns on it. It's just simply the case that a contract of service is how you describe employment, but a contract for service, or if you like, contract for purchase of service, is more related to contractors. Okay, well, let's discuss statutory regulation. So, harking back to what I said before, there is clearly a requirement to have some form of regulation of the labour market. So, how is that done? How is the labour market regulated, particularly by the state? Well, it can be done through the imposition of obligations on employers. For example, the state may, by legislation, require employers to keep employment records, to keep the workplace safe, and to provide a certain minimum amount of leave. The state also authorises courts and tribunals to make rules and regulations, including awards, and it permits the registration of enterprise-based agreements in a manner which we'll describe shortly. It can prohibit through legislation certain conduct, such as discrimination on the basis of race or gender or union membership, etc. And in some states it can authorise the courts and tribunals to vary employment contracts where they contain terms and conditions which are harsh or unfair. And of course, even in a common law sense, it's possible to ask a court to determine that a condition that's imposed upon you as an employee is unfair, so that it becomes unenforceable. Any conversation about employment law will usually come around to a discussion of awards, and we will talk a little bit further later on about how awards are made, but let's think for a second about what type of awards there are at the moment. If you go on to the Fair Work webpage, you'll see, or you'll be able to access the awards which currently exist within Australia, and there is a record of them. I mean, there'd be no award which was current and which was enforceable, which wasn't on that page. But there've been a lot of changes in the last 20 years around awards. In particular, two things I wanted to draw to your attention. One is that with the modernisation of awards, there are only certain allowable matters that can be included in an award. Now, there's a bit of history around this which I won't go into here and now, but essentially there was a move, or there has been a move over the last 20 years to simplify awards. So when you see the word modern awards, think simplified or shortened awards. So there's been a move towards the registration of agreements instead of having awards, but where awards still exist, they must be simplified. So there's a list of allowable matters. I'm going to ask you later to have a look on the to do some research and have a look on the Fair Work web page for a bit more detail around this. But just as some examples, allowable matters include flexibility. So every award should refer to a flexibility arrangement within the workplace. In-house settlement of disputes. So there's a real pushback trying to get people to resolve their workplace disputes using in-house sanctioned processes and procedures, and they should always have a nominal expiry date. There was a much more lengthy list of non-allowable matters, things that just weren't allowed to be included, but that's been watered down somewhat. But there are still some matters which cannot be included, and that includes provisions which are said to be discriminatory, any change or attempt to change the unfair dismissal laws, and various rights of entry provisions. So the right of employee organisations to enter the property. These are things that are regulated by legislation and they can't be changed. Now, I want you to think about, as part of the introduction to the course, I want you to think about the Constitution. Hopefully some of you have completed constitutional law, but if not, these are the main sections that I want you to be aware of. First and foremost, be aware that Section 109 of the Constitution says that where there's any inconsistency between a Commonwealth law and a state law, it's the state law which is going to prevail. And so for that reason, any discussion that is around the expansion of the Commonwealth role in employment law automatically means that there's a corresponding decrease in the influence of the states. And that's what the tension's been about over the last 20 years. So if a state law is inconsistent with the Commonwealth law is automatically going to prevail to the extent of the inconsistency. In reality, that usually means when the Commonwealth makes a law on a topic, all of the state laws disappear. Have a look at Section 51 of the Constitution, particularly subsection 20, 29, 35 and 37. And they're the sections which deal with the power to make laws regarding corporations, the power to make laws with respect to external affairs, the power to make laws with respect to conciliation and arbitration and to prevent settlement of interstate industrial disputes. And that's probably the oldest power that was used by the Commonwealth. And finally, the power under Section 37 for states to refer matters to the Commonwealth so that thereafter the Commonwealth can make laws about them. Now, there was for many years a great fiction, and the fiction was this. Under Section 51(35), the Commonwealth could make laws with respect to conciliation and arbitration and prevent and settle in interstate industrial disputes. And the fiction was that employees and employee organisations, trade unions, etc., would come up with a log of claims which, surprisingly, would be would create an interstate dispute. So in other words, they would on behalf of a number of employees across a number of states create a dispute by claiming lots of outlandish things, and they would be therefore allowed to go to the Commonwealth Conciliation and Arbitration Court. They'd be allowed into the Commonwealth system to have that dispute sorted out, and the end result of that would be an award. And so each year the unions would come back and file another log of claims. They would sometimes rope in other employers, and the whole idea of the system was to first create a claim so that you could trigger the Commonwealth's power to have some jurisdiction and sort the complaint out. It led to a system of awards which were based very much on occupation or industry, and as I've said here, it was very much a great fiction. You'll see later that the whole system has moved well away from the requirement to start a dispute, fictional or otherwise, before the jurisdiction of the Commonwealth can be enlivened. Now, instead of all of that rigmarole, what's happened now is over the last 20 years, the constitutional basis for the Commonwealth legislating and regulating in this area changed first and foremost to the use in the early 90s, 1993 and 1994, in changes to the Industrial Relations Act, to the use of the External Affairs power. I mentioned earlier the International Labour Organisation that the Commonwealth is a party to. So acting on ILO recommendations to move and to promote enterprise agreement as opposed to the old system, changes were proposed to the Industrial Relations Act, and in 1996 in the Industrial Relations Act case, the High Court said that the Commonwealth did have power to make laws with respect to employment in part, relying on the Foreign Affairs or the External Affairs power, which I mentioned earlier. It was subsection of 51, namely 29. The move from there went even further, so that with the introduction of the Fair Work Act, the Workplace Relations Amendment Act, the so-called Work Choices Act in 2006, almost 75% of the workforce suddenly came across to the Commonwealth system, and that's because using the Commonwealth's power to make laws with respect to corporations, all of a sudden every employee of a corporation was covered by Commonwealth law. And I guess just for completeness, I'll mention that, as was always the case, both the territories and the Commonwealth agencies were already under the Commonwealth legislation. So a really big change with the Work Choices legislation in 2006, away from that system that I mentioned earlier, where you had to come up with some sort of interstate dispute to enliven jurisdiction, to one where the High Court accepts that the Commonwealth does have the power to make laws regulating employment arrangements of corporations. Now, just for completeness, by 2009 the states had, or most of the states other than Western Australia, had given away any argument about this issue, and in 2009 under the Fair Work Act, all of the states other than Western Australia referred their powers in this area over all private sector employees to the Commonwealth. Now, there are still some state employees who are regulated under state laws, and they're of course state officers themselves, so senior staff within the state public sector, state public servants, and that includes people like police, etc. and local government employees. They're all still regulated by state laws. And there are, of course, state laws which are still in place with respect to the employment arrangements and the employment relationship, and they relate to workers' compensation. So each state has its own workers' compensation system, discrimination laws, health and safety laws, laws regarding long service, and laws regarding child labour. Still very much state laws, notwithstanding what I just said about the Commonwealth taking over. And there are still state regulatory bodies which operate. So there are state industrial relations commissions, anti-discrimination commission, and most of the states now have a commercial and administrative tribunal. In Queensland it's QCAT, in Victoria it's VCAT. That state body still has the power to determine disputes, but pretty much limited to discrimination or occupational regulation. So, in other words, if I'm struck off as a solicitor, I'll, in the first instance, be able to go back to QCAT and ask them to decide whether I should be struck off or not. All right, well, let's talk about some of the Commonwealth regulatory bodies. Well, the big one, of course, the big ones are always going to be Fair Work Commission and the Fair Work Ombudsman. And I would very much urge you to have a look at the web pages for both of those organisations this week. They're going to be a source of the law for you and a source of information about the employment relationship over the next 12 weeks. So make sure you know how to find the Fair Work Ombudsman's web page and the Fair Work Commission web page. The Fair Work Commission, the role of the Commission is aimed at adjusting minimum wages, reviewing and updating awards, sorting out industrial action between groups, including employer groups and unions, etc., dispute resolution about specific issues, approving enterprise agreements, a very big part of what the Commission does, ensuring that enterprise agreements which are put up meet the national employment standards and are fair. Fair Work will hear and determine disputes under awards and under national employment standards, and they have a big role to play in sorting out disputes regarding unfair dismissal. They do their work through the appointment of commissioners, but they also appoint, the Fair Work Commission also appoints expert panels to do things like reviewing the national wage, minimum wage each year. And at the moment, just out of interest, they're reviewing the penalty rates or the application of penalty rates. So if you are interested, have a look at the penalty rates case, which is being heard at the moment. But the bulk of its work is dealing with disputes between employers, workers and unions. Note the comments in your textbook also about the way the Commission works. You'll find that it operates quite differently to a court in many ways. It can anticipate disputes and call parties together for a start, and the rules of evidence are not as strictly applied. Note also the fact that these panels, which are put together to deal with specific issues, are often staffed by experts rather than by judicial officers or full-time commissioners. The Fair Work Ombudsman, on the other hand, is very much aimed at promoting compliance, investigating, prosecuting, educating and providing advice. This is just a role that very much, I guess, is aimed at that educative and advice aspect. On the front page of the Fair Work Ombudsman's webpage, you'll see reference to information regarding pay and leave, what happens when employment agreements come to an end, information about entitlements, etc. So a very useful regulatory body, the Fair Work Ombudsman, but aimed perhaps a little bit more towards education, advice and compliance. All right. We need to, I guess, round off by thinking about, well, what happens if things go terribly astray? And the answer to that is that the federal courts are the place that these disputes are heard. Now, if I come back to the constitutional point I was making earlier, the Constitution provides us with our ultimate guidance regarding jurisdiction, and if I said as a general rule, Commonwealth courts deal with Commonwealth matters. We'll talk in more detail later on about the process of enforcement, but Commonwealth courts generally deal with Commonwealth matters, and that includes discrimination. Both the Federal Court and the Federal Circuit Court have a Fair Work division, which is there specifically to deal with disputes which arise under the Fair Work legislation. But be aware also that the common law claims, so where a person is not covered by either a modern award or by an enterprise agreement, they simply have a dispute based on contract, they can still be brought in the state courts, and they often are. And also that's of course the place where claims for damages for negligence, for workers' compensation, and for breaches of workplace health and safety are dealt with. They're all dealt with through the state courts. Finally, let's just consider for a moment the role of unions and industrial organisations. There is an Australian Council of Trade Unions which represents something like 25 or 26 trade unions, but overall there are around 50 registered unions, and when I say registered I mean that they are registered under the Fair Work Registered Organisations Act. The reason that a union would become registered under that Act is that they are given standing to appear in disputes, and what I mean by standing of course is that only parties to a dispute can be heard by a court or by a commission. Just because you're interested in a proceeding, you don't automatically get the right to turn up and start arguing a position. You need to have standing. So unions automatically have, registered unions automatically have standing to be involved in disputes. So they still have a very special place to play in employment regulation. But having said that, there's certainly a change in the way that unions are being perceived, and there's a much smaller participation in trade unions these days. You could probably argue that that's because of a variety of reasons, and it may simply be because of this move away from having to have an argument every year to improve an award towards an enterprise-based system where workers at the particular business or enterprise argue for their own enterprise agreement. Changing economic conditions, plus the fact that you no longer need a dispute to have a matter dealt with under Fair Work. Employee and industry groups likewise are called on to give evidence, particularly at hearings such as determinations around minimum wages, and they are involved at the moment, of course, in the discussions around penalty rates. All right, well next, that's the first part of this discussion. The second part will be a discussion regarding the development and the coverage of employment laws.